Hi everybody, and welcome back to Bowdie Shorts, making law make sense in 15 minutes or less. In this episode, we're looking at one of our final topics in tort, the topic of nuisance. Now, students often find nuisance frustrating because there appear to be three different torts being discussed at the same time. Private nuisance, the rule in Rylands and Fletcher, and public nuisance. The good news is that they are all trying to answer slightly different questions. So for SQE purposes, most nuisance problems can be solved by asking what exactly is interfering with the claimant and who is being affected. Once you answer that question, the correct cause of action usually becomes much clearer. Let's get started. So the big picture here, think about the torts we've studied so far. Negligence focuses on careless acts. Nuisance is different. Nuisance focuses on how one person's use of land affects somebody else. That's why nuisance is often described as a tort concerning land. And the central question is usually, has the defendant's use of their land unreasonably interfered with somebody else's use of theirs? So what's step one? Well, first thing we need to work out is which type of nuisance. Now, whenever you see a nuisance problem, this is where you need to start. So private nuisance is the situation where one person is affected in relation to their land. Rylands and Fletcher is where something dangerous escapes from a person's land. And public nuisance is where the public generally are affected by somebody's use of land. That simple classification solves a huge number of SQE questions. So let's have a look by looking at private nuisance in a bit more detail. So private nuisance protects a person's use and enjoyment of land. Notice the emphasis on land. This is crucial. Private nuisance is not primarily about protecting people, it's about protecting interests in land. So what counts as an interference? Well, the courts have identified three main categories. Encroachment, for example, tree roots, overhanging branches, objects that cross the boundary between two pieces of land. Physical damage, for example, flooding, fumes, chemical damage. And loss of amenity, for example, smells, noise, dust, and vibrations. And the final category is often the one students associate most closely with nuisance. So when is the interference unlawful? And this is where many students go wrong. The question is not, was the defendant careless? That's negligence. Instead, the question is, was the interference unreasonable? Now, nuisance is all about balancing competing land uses, and the law recognises that neighbours inevitably affect one another. The issue is whether the interference becomes excessive. So there's a number of factors we need to consider. The first one is duration and frequency. One loud party is unlikely to be enough to found a claim. Constant loud music every weekend for years is much more persuasive. So the courts generally expect some continuity. This is one reason nuisance is different from negligence. Negligence can arise from a single careless act. Nuisance usually requires an ongoing problem. The second factor is the extent of the interference. The greater the interference, the more likely it becomes unreasonable. Think about noise. Background noise may be acceptable. Noise that prevents sleep every night is a different matter entirely. And the same applies to smells, fumes, and vibrations. Factor number three is the character of the locality. And this is a classic nuisance principle. What is reasonable in one place may be unreasonable elsewhere. For example, a level of noise acceptable in an industrial area may be unacceptable in a quiet residential street. The courts therefore ask, what would be normal in this particular neighbourhood? And that context matters enormously. We then come to malice. Students love this one because it feels so human. Suppose the defendant is doing something purely to annoy the claimant. That matters. The courts are more likely to find a nuisance where the behaviour is motivated by spite. A perfectly acceptable activity may become unlawful if carried out solely to cause trouble. Who can sue is next, and this is one of the favourite SQE traps. Not everybody affected can sue. Following modern authority, a claimant generally needs a proprietary interest in land. That usually means owner-occupiers or tenants, but generally it does not include guests, children living at the home, and lodgers. Remember, private nuisance protects interest in land, therefore the claimant needs to have an interest in that land. Who can be liable? Well, usually the creator is the person. So the person who created the nuisance tends to be the person most likely to be liable. But it can also be the occupier, the person who controls the land. Sometimes it can even be a landlord, particularly if the nuisance was authorised or known about. For SQE purposes, the occupier is often the obvious defendant. Remedies. Private nuisance is unusual because damages are not always enough. A claimant may want the interference to stop, and this is where injunctions become important. An injunction is simply a court order directing or prohibiting conduct. Students should remember injunctions are a key remedy in nuisance that makes nuisance different from ordinary negligence claims. Now let's look at the strange cousin of private nuisance now, the delightful rule in Rylands and Fletcher. Now this exists where something dangerous escapes from the defendant's land. Think of it as a really specialised form of nuisance. Now there are 4 elements to consider, and these will be relevant to looking at SQE questions on the Rylands and Fletcher concept. So did the defendant bring something onto the land? Was it likely to cause damage if it escaped? Was the use of land non-natural? Did it escape, and did it cause foreseeable damage? If all 4 are present, then the rule applies. So what is escape? Because that's got to be our first question here. And this is essential. The dangerous thing must move. So it must move from the defendant's land to somewhere else. No escape means no Rylands claim. And students often forget this element. Always check for movement beyond the defendant's control. What's non-natural use? Well, this is another favourite for exam questions. Ordinary use is not enough. The use must be extraordinary or unusual. And this is a high threshold. Modern courts are generally reluctant to expand Rylands liability. As a result, Rylands tends to appear less frequently than traditional private nuisance matters. Let's now look at public nuisance. This differs fundamentally from private nuisance. So private nuisance, as we remember, protects private land interests. Public nuisance protects the public generally. So classic examples include obstruction of highways, dangers affecting a community, and activities threatening public safety. The key question to ask is this affecting a class of people rather than an individual alone? If the answer is yes, public nuisance should immediately come to mind. Now, can an individual sue? Yes, but only if they suffer particular damage. So in other words, they must suffer harm beyond that suffered by the public generally. That special damage might include personal injury, property damage, financial loss. Without particular damage, the claim normally belongs to public authorities rather than to individuals. Negligence or nuisance? Well, students often struggle to distinguish them. A useful comparison says that negligence focuses on careless conduct. Nuisance focuses on unreasonable interference with land. Negligence asks, was the defendant's conduct unreasonable? Nuisance asks, was the defendant's use of land unreasonable? And that distinction is incredibly important. So what's Bowdie's bottom line? Well, every nuisance problem starts with classification. Ask, is this interference with somebody's land? If so, think private nuisance. Secondly, has something dangerous escaped from land? If so, think Rylands and Fletcher. Thirdly, is a section of the public being affected? If so, think public nuisance. Now, for private nuisance, specifically remember, it's got to involve interference with land. It's got to be an unreasonable interference. There's got to be a proprietary interest involved, and injunctions are often the outcome that are being sought. For Rylands, remember, dangerous thing, non-natural use, escape, foreseeable damage. For public nuisance, remember, public affected, individual needs particular damage to bring an individual claim. If you leave this particular video remembering those three categories and how to distinguish them, then you are well equipped to tackle SQE nuisance questions. Thank you for watching this particular Bowdie Shorts. There'll be further series available in the near future.